really very hard to make that judgment. Other questions? Other questions back there?
Well, first I'd like to make a comment. There have been special cases related to a disabled golfer, where it's a very narrow case,
Yes.
referring to yours. And there was also another case related to an Olympian where it impacted one or two people. And in those instances, the Supreme Court effectively is only making it a very narrow, not to be quoted decision. As far as Hoffman Plastics, I read both the presiding and dissenting opinions, and I thought it was outrageous that any member of the Supreme Court could effectively say, it's okay for these guys who are, manufacturers to abuse the law. And I think one of the issues is, as a member of the press, I don't think the press reported it so the average person could understand it. Another case that was interesting is Alden versus Maine, related.
Well, that's...
Yeah, I know. Well, that's the one I was referring to. And
why don't you say what that is, so we'll know which of the many cases that were referred to.
Oh, okay. In any case, in Alden versus Maine, I think Kennedy wrote the presiding and Souter wrote the dissenting, and it was shocking because effectively after the decision, I believe Maine went back and said, okay, we're going to give them overtime anyway. So it's almost like the state superseded the Supreme Court decision after the case, probably because of political issues. I'd like to throw a question out to everyone on the panel related, well, it's a two-part question. One is, what do we have in the next 5 years where Stevens is 80 and Renhquist is 78, and who do you suggest is going to be, let's say, the two new members and or the Chief Justice? And that again, the other one is the issue of, I guess, verbal witchcraft that was referred to on the panel, where you get all of the precedences that are in left field when in effect you want a clear, concise determination. And even those people who are liberal on the court are effectively very conservative, and that would be reflected in X. Earl Stevens versus State of Vermont and the False Claims Act, where okay, well, I'll throw that up, but take it from there.
Okay.
From a camera person.
Well, you put a lot on the table. Let me point out something that may be obvious, and that is the terms of the debate and the discussion have really shifted over the years. I mean, all the words about strict constructionist and so on had to do in the Warren Court with the court seeking to give content to those broad concepts of equal protection and due process, which are not defined in the Constitution, and the view that the court had gone too far, as Norman says, with such matters as root and branch. Now it is shifting really to the court, the 5-4 majority in the court, not so much expanding rights through interpretations of equal protection, but denying the other branches of government, and particularly the Congress, the right to use the Commerce Clause, to use the 5th section of the 14th Amendment to give content to rights. And that's, I mean, I think Norman has said that, and other people have said that, but it's very important to focus on that. So I really think, one needs to look at particular questions. I think the whole question of affirmative government is really what's at stake here. One needs to look at whether you think that it's appropriate for the government to serve as a countervailing power against corporations, to protect consumers and investors through the SEC, to give content to the laws with respect to the environment, and yes, to give content to the civil rights laws with respect to disability and age, as well as race, ethnicity, and gender, and not to have have concepts like the one Norman referred to of congruence and proportionality erected as barriers to government serving these affirmative purposes. I think there's a debate to be had about all this, but let's have it about what the issues are that are at stake. And right now, it's the court not only curbing its own interpretations, but preventing the whole concept of affirmative government from being implemented in a good many areas. Let me just add one thing to all of that, and that is I don't think that the Congress, Norman, or the people in the Congress are flummoxed by the abstruse nature of the debate. There are some very strong people in the Congress right now, and if nothing else, apart from their legal knowledge, they are certainly aware that, when they've had 2 years of hearings and made findings to support the Violence Against Women Act or to support the disability laws, and the court just throws those out in a single case and says, we know better. The Congress is aware, people in the Congress are aware of what's being done. And there were some very good hearings, for example, on the Kimmel case, which was the Florida 11th Amendment case. The problem is that in today's world, there are so many issues, whether they have to do with the war or with terrorism or with a huge number of things that members of Congress suffer from attention deficit disorder. They cannot stay with issues. They do not stay with issues for a very long time. And the only way to deal with that is for people who are concerned about this. And I don't know what's going to happen with respect to the court. I don't know how many nominations Bush is going to get. But it's a question of whether people will stand up and debate the issues. And it really is going to require better organization and more effort on the part of people who know about and care about these issues to get members of Congress to say, I need to give a greater proportion of my time to these issues.
I don't know if that answers your question, but let's call on some others. Yeah.
My question was raised by Professor Ogletree's article and Mr. Bryce. Obviously, neither of them are here, but they talked about the Sixth Amendment obligation of the government, and especially in capital punishment cases, the sort of weak representation we're seeing. And I just wonder if any of you have thoughts about what is required of the government under the Sixth Amendment and what can be done, especially in capital cases, to deal with the problems with representation that we have for poor defendants.
Under this, I'll just say very briefly, under this Supreme Court, nothing. This court has continually ignored dreadful examples of misrepresentation and has made it almost impossible to raise those issues by narrowing habeas corpus to a very, very narrow area of things that where there's a terrible mistake of something that clearly was wrong, but that's not the way it works. And Congress has gone along by passing legislation. So I think the answer is no. Another question back there, I think there was. Yes.
I just want to say thank you very much, because I am just thrilled to be here. I'm a fourth-year student at New York Law, and James Simon is my professor.
Oh.
Yeah, and I've been very fortunate. And I really did catch the idea of the pattern, and I think this is so important that I really feel what's been happening is the state of anxiety for people that are aware or certainly care, and the recognition that we're really, I think at this point, it feels like we're doing very little as a public, maybe in the Bar Association. Recently, the U.S. citizen who was held without, I think, having charges against him, as well as without counsel, out there in the newspapers, clearly unconstitutional. It feels as if things are happening today, President Bush getting out and, I don't know, really almost making his, I don't know if that happened in the past, but really pushing against the Michigan affirmative action. I mean, strongly moving in there. And I'm just saying, it feels as if somehow things are slipping away, and in subtle ways and in very, I guess, blatant ways, and how we can work against it. And I do think we need panels like this that really raise it up.
It is very interesting that I was Corporation Counsel of New York City, and I can never remember an instance in which Mayor Lindsay announced the position that the Corporation Counsel was going to take. That was our responsibility, and it was really quite unusual that President Bush announced the brief that the Justice Department was going to file.
I just wanted to say a comment first and then a question. There are certain groups here in New York and other places that are very interested in this issue. The National Campaign to Restore Civil Rights, NCRCR, and Equal Justice Society, the Leadership Council, LCR, Leadership Council on Civil Rights, I believe. And these are groups that are people in the academia, law students, organizers, who are very interested in strategizing on how to combat judicial nominations, the attack on civil rights under the guise of federalism and sovereignty. So this is wonderful that you're here, but if people are interested in specific ways as to how they can become involved, the New York Lawyers of the Public Interest is one organization that is organizing this, and the website is nylpi.org. So that's my comments. I do have a question. What are some suggestions that you would have in terms of how the association could become involved? Those who are interested in this issue, what are some ways that you think the association can take in order to try to combat these issues?
Well, I think that's a subject that should be pursued at some length. I think this bar association and other bar associations over the years have been honest brokers, have been important in various times in our history in preserving the integrity of the courts and looking at excesses. I mentioned one thing before. I think the organized bar ought to be the source of names that could be put before the public of people who could serve even though I mean, the notion is there are the Bush nominees and then there are all these liberal Democrats, but there are other people out there who should be considered for judicial service. I think there's a continuing need to define what are the responsibilities of federal judges, and some years ago I helped in the Bork nomination. I helped Philip Kurland and Larry Tribe write a letter that helped define those responsibilities, and I think that's necessary today. I think the bar ought to be a source of that kind of measuring rod or standard for what kinds of judges we ought to have. I think there are important things that since I'm only a part-time law professor, I can say this, but I think that often too many law professors fall into the notion that a federal judgeship is the reward for scholarship, regardless of what one's values may be. So I think there are a whole lot of things, and I think students, as your question suggests, are more energized, and I've said to them that things that they already know, and that is that the future of the court may determine the future of their legal careers and whether they can have successful and productive legal careers. So I think there's a lot of education to be done, and there's a lot of standards. There are a lot of standards.
You have been kind enough not to mention one thing that particularly annoys me, and that is that bar associations and committees of bar associations have been flooding the media with their indignation over the proposed regulations that the SEC is putting forward with regard to the Sarbanes-Oxley Act. And there's a lot that's wrong with that act. I don't want to go into the details, but what you're hearing is segments of the bar that are outraged over that act, and I haven't heard much at all about being outraged over what has happened with the Supreme Court in the area of civil rights.
I'd like to say, with the more respect that I showed initially to your question about debate, that debates. I think so that more people, I think you should have debates with the Federalist Society, and they're very good at this.
They're very
And they're not only good at it, it's not a secret society. The Mein Kampf is all, it's written, and it's all there.
They're always nice.
And anybody could go. But I think that it's ingeniously democratic and open. But I think that's a good idea for progressive groups to look to. That's one piece of their example that I would follow. And I think we're vulnerable to the argument that we don't have anybody to debate us. But I don't know how you take us on. We're so formidable. We're far of us.
Yeah, you had a question, I think.
Yes, I think that whether you're on the right, whether you're on the left, I think that we all can support and endorse the concept of judicial integrity. And certainly I've been very bothered by the repetition that I have heard from, I think, all of you as to the degree of unprincipled, results-oriented decisions, which is misconduct. Now, the bar associations don't like to address issues of judicial misconduct for sure. And one aspect that I would like to bring to your attention in the event you are not aware, in 1993, the National Commission on Judicial Discipline and Removal came out with a recommendation that the justices of the Supreme Court should set up a mechanism for judicial misconduct complaints against themselves, because they are not within the rubric of 28 U.S.C. 372C, which is the mechanism that purports to discipline or provide some redress, disciplinary review of lower federal judges. Notwithstanding that recommendation, the justices of the Supreme Court have made no progress, have done nothing to set up a complaint mechanism. There are complaints against the justices of the Supreme Court. They go nowhere. They are ignored by the justices of the Supreme Court. Indeed, apropos of Jack McKinsey's wonderful book on the appearance of justice, I should say that this includes the disregard by the justices of the Supreme Court with conflict of interest issues, disqualification applications made to them. They simply ignore disqualification applications. So my question to you is, what do you think the left and the right can do to put together some sort of mechanism whereby the justices of the Supreme Court will be accountable to some sort of complaint mechanism? The House Judiciary Committee ignores complaints.
Well,
Norman has worked on
Justice Scalia last weekend in a speech in which he said that the court, he was annoyed that the court had driven God from our life or whatever. I mean, that's an issue that the Supreme Court's going to have to deal with. References to the Ten Commandments, to God, in schools, and for the Justice of the Supreme Court to say that the court has been wrong in driving God out of public life is just wholly inappropriate. The problem I have with dealing with these issues, I can, those of us who are my age can still remember the Impeach Earl Warren signs. And a lot of that was put up by people who genuinely believed that Earl Warren didn't know what he was doing. He knew definitely what he was doing. But drawing this line between those who, I'm all in favor of having justices appointed who would not follow the route that has been taken by the Renhquist court. but it would be a rare instance in which I could conceive of action being taken against one of the judges who reached the conclusions that were reached in some of the cases I've described. I do think that Justice Scalia went over the line, and I don't see anybody taking any action with regard to that.
Let me say that's not the first time Justice Scalia has commented on issues, particularly in the religion area as well as in the capital punishment area, that are coming before him. But the problem is there is no groundswell for that kind of thing. I actually once, in the pages of the ABA Journal, debated the issue with then Senator Alan Simpson, who said, it's not a problem. And Scalia said at his confirmation hearing, refused to discuss any case, even a question about obviously the Orr grandfather, Marbury against Madison, because it might come before him and he was not going to state anything. Really meaning, I don't want to jeopardize my confirmation. But that's, since then, I think more than any of the others, perhaps, I don't know if any of the others has done this, but the issues that we've been talking about up here, really, they're doctrinal issues. They don't lend themselves to that kind of thing.
Conflict of interest, of course, is not doctrinal.
I understand. I understand. And there were serious conflicts of interest in Bush against Gore, involving relatives of Clarence Thomas and Scalia.
But were applications made for disqualification?
The answer is no, but it wouldn't have made any difference, almost certainly.
But there are cases coming up where applications are made, the justices simply ignore them. They don't deny them, they simply ignore them.
I think that's right.
And there's no complaint mechanism to deal with their disregard of formal applications for disqualification and disclosure.
I guess I think it's important for people who are specialists in our concern, like Stephen Gillers at NYU and others, to keep raising these questions and putting them before the public. I don't know that they're likely to be solved by a mechanism, because the powers of the justices are fairly plenary in this regard. But it is. I do think it's important that these issues not be ignored.
We have about 5 minutes left, so just last questions, if you will. Yeah. Before you ask, is there somebody who hasn't asked a question who would like to? Go right ahead.
I have something I think is important, and it's a bit of a criticism of the panel. We've criticized a lot of these decisions because, in effect, they're boring our liberal locks. We don't like the results. But what we haven't done, in contradistinction to the Federal Society, is articulate a good sound view for why that they should be, why they are good, and a fundamental structural overall view, and that is that since the beginning of our country, the Constitution, Marbury versus Madison, a bunch of steps where we concentrated and solidified federal power because our society got bigger and more complex, and you can't run a lot of these issues by states' rights. I mean, you can't have different gauge railroads and highways that are all different sizes. And a lot of what we're doing is an imperative driven by the fact that we are a big, complex society. At a time when the European Common Market is harmonizing and centralizing and trying to make their laws the same, we are moving in the other direction. And it is an absurdity. It is perfectly fine to say there are certain things that are better done by the states. But those things have been shrinking since the beginning of our country, and that's why we accumulated all of these laws and accumulated federal power. You can't deal with the Enron scandals, et cetera, and the public stock markets on a state-by-state basis. That's absurd. We have a very complex, integrated national economy where the whole thing works together. And there are many of these things where we're trying to regulate, and it can only be done from a centralized base. And we just are not making that point strong enough. We are letting the crazies who yell for states' rights in a mindless way get away with it, and not pointing out the necessities for integration. The military has to be integrated. The first thing they did with Homeland Security is try to rationalize national laws. We ain't making the argument, Ron.
I think, in all fairness, we may not be making it now, but if you look at the cases that have authorized the expansion, right from the beginning, cases like Wickard and Filburn, which refer to a small amount of wheat for home consumption. If you look at all of those cases, including different gauge and trucks and that kind of thing, they all make the point. They actually go back to the 1880s with talk about the need for an integrated economy.
But we are making the point in arguing against the federals.
I think, well, I don't know whether we are, I don't know who the we is, but the fact is that to a large extent, we actually act on it. You notice, of course, that Congress has no hesitation when it satisfies the majority to just toss aside states' rights. The Defense of Marriage Act, product liability, you can go down the whole list. I don't have much more to say than that. I mean, the defense of this, perhaps it's naive, perhaps I'm too old, but the fact is, it seems to me that so much of this is self-evident, and what we are seeing is basically an attack by people whose views are not particularly shared by the bulk of this country, but because of the nature of our political structure, in which the Senate is given this inordinate power based on states and a variety of other things. Power has moved over to this group, which I don't think represents the mainstream. In terms of the question that was asked before about bar associations, this country is committed to equal justice under law. The bar associations all say that. The Judiciary Committee will say that. And judicial nominees are supposed to show a demonstrated commitment with specific actions, a commitment to equal justice under law. The Bar Association, I'll just say this, Jack, the Bar Associations have not insisted on that. And yet, they are ostensibly committed to it.
I should really let it close on that, but I would like to say that I don't think the Renhquist majorities are into different gauge railroads. I think that's a cartoon. It's much more subtle than that, and it's serious, very serious. But I think they understand about that aspect of interstate commerce, and they don't. That's not their battleground. So
no, but what I'm saying is that in order to articulate a better argument for the centralized government's powers that we want to use for these other many things, I think one needs to rebuild an understanding in people that this comes from what Professor said was self-evident. It's not so self-evident anymore. And if we can relate these complex issues where we want national regulation to some of the simpler ones, we can make the case better that, look, in a new complex society, these issues are like those old ones, and they need to be centralized.
I wouldn't do that. I don't think that's smart. I don't think that's a smart debating tactic at all. I think that takes us way away. I personally just.
Whether or not it's smart and whether or not it's politically wise, I really think that you were right, and that there's a very great irony. You have Europe, as you mentioned, Europe. Human rights in Europe is a supranational issue. It's not a local issue. Human rights in the world is an international issue, and yet we're devolving it locally when it must be protected internationally.
I guess I think very briefly
that we're better off dealing with the matters that concern us and not dealing with them abstractly. And the question is, because people don't think about them in terms of states' rights or otherwise, what is it that we as a society want to accomplish, and to what degree is the Supreme Court, through its, the Supreme Court majority, through its decisions, making it difficult or impossible to achieve those things? And I think that globalism and commerce, in the sense that you're talking about, does come into that argument. Thank you.